Good morning. Happy Thursday. I'm on my way into court. I got a comment yesterday from someone who calls himself a Chilli supporter. And that comment had two parts. And part number one was the person thought that Chilli's sentence was excessive. And that's an opinion thing, and I can't argue with that. I can't say that it wasn't excessive in your opinion. Obviously it was well within the realm of sentences that the judge could give. It was not the highest sentence that the judge could give. It is a lot higher than I would have expected Chilli to receive. Simply because I would have expected someone facing those charges to have negotiated a settlement, negotiated a plea deal. And a plea deal probably would have been something like 90 days suspended and $500 in fines, something along those lines. That would be a reasonable plea deal. Chilli chose not to choose a plea deal, so Chilli got to roll the dice with what the judge is going to sentence him with. And your opinion is that it's excessive. Fine. I don't think that a court of appeals, I don't think there's any grounds for a court of appeals to find it to be excessive. The other part of the comment was that it was essentially the state of Nevada protecting the Las Vegas Municipal Police, LVMPD, Las Vegas Municipal Police Department, from liability. It was a response, according to this person, to Chilli's lawsuit, and the purpose was to essentially bar Chilli's claims by getting a conviction. Thus, the Heck doctrine, Humphrey versus Heck, Supreme Court case, would come into play, and Chilli would be barred from recovery. Unfortunately, no. First of all, Chilli's lawsuit against the LVMPD is, for the most part, done. The only real cause of action that he has left, after the court dismissed the wrongful arrest claims in the first motion to dismiss, the judge dismissed those claims with prejudice. And just because Chilli repled them in his amended complaint, or his second amended complaint, or whatever, just because Chilli repled them doesn't mean that they're actually in there and valid. They have been dismissed with prejudice. Words mean things. If a court says with prejudice, the court means with prejudice. Chilli didn't file any motion to set aside or appeal or reconsider that order that dismissed those claims with prejudice. So they're dismissed with prejudice. Chilli repleting them doesn't change anything along those lines. So all of the wrongful arrest claims are dead. That being said, the wrongful arrest claims are different than what was addressed in Heck. In Heck, there was a conviction. And pending appeal, while the appeal was pending, the defendant in the appeal filed a 1983 lawsuit. And the Supreme Court essentially held that you can't file a 1983 lawsuit for a wrongful conviction or wrongful imprisonment post-conviction unless and until you get that conviction overturned. You have to essentially challenge the constitutionality of the conviction prior to filing the 1983 lawsuit. Now, notice it's for a conviction. The Heck doctrine would apply if you're filing a 1983 lawsuit for wrongful conviction or wrongful imprisonment. Chilli has not filed a 1983 lawsuit for wrongful conviction or wrongful imprisonment. He's filed a 1983 lawsuit that was essentially alleging wrongful arrest. It's, again, words mean something. a lawsuit for wrongful arrest is not a lawsuit for wrongful conviction. Now that Chilli has been convicted, he could, in theory, I'm not saying he has a cause of action for it, but he could, in theory, file a motion for wrongful conviction. Not a motion, a lawsuit for wrongful conviction. I'm just seeing opposing counsel going by. That was him. You just probably saw him over my shoulder. And he got a haircut. No, he didn't. It was just the sunlight. The guy looks like a doofus. He's a really good attorney, but boy, he looks like a doofus. And we're both wearing, I think we're wearing the same shirts, which is going to be a little awkward. It's the small things in life. But anyway, back to the point. The point was that the heck doctrine doesn't apply because, number one, all the relevant portions, it could even, in theory, they don't, but in theory, they could kind of apply. The wrongful arrest portions have already been dismissed with prejudice. So they're not valid anyway, so the heck doctrine doesn't even come into play. Number two, the heck doctrine wouldn't come into play because he didn't file a lawsuit for wrongful conviction. So all that Chilli really has, the only real cause of action that Chilli has left, I mean, the only one with even a chance of surviving the motion to dismiss, a chance of making it to trial, the only thing he's got is the excessive force. That's it. That's all he's got, excessive force. That is a Fourth Amendment claim, but it's not a wrongful arrest claim. It's the method that they use claim. Punching him in the balls could, in theory, be argued to be wrongful or excessive force, right? Pinching the ulnar nerve in his arm, sure, I guess you could sue for it, but I mean, good luck, right? But that's the only real cause of action he has with any potential for a recovery that I can see. So I hope that makes sense. I hope you understand it, whether you do or you don't. I have informed you about it. What always gets me is when after I explain something, people are like, can you explain why? Like, did you not watch the fucking video? I mean, I've already explained it once. This is the Dunning-Kruger Olympics. It goes on in my comment section. I've already literally explained it once. Did you watch the video? Watch it again. I'm not going to go into the comment section and like spend 45 minutes to an hour trying to get you, the dumbest of the dumb, to understand what may be too complicated for you to understand, regardless of how much time I spend. I have just explained it. If you don't get it, sorry. Move along. Thanks for watching. Have a great day.